For many of us, the start of the new year is a time to reflect on our finances, our health, our goals, and experts say funeral planning should also be on that list.
WMAR 2 News' Maui Safaste sat down with an estate planning attorney to get answers to the questions some of us are maybe a little hesitant to ask.
What we learned is it's not enough to have a will, particularly if that money is going to minors. A local mom told us her story of how a loving gesture turned into a legal nightmare.
In her last act, Heather Cook Case's mother-in-law left her grandchildren part of her estate. She wanted to gift them something in her absence, but it wasn't the smooth process she had hoped.
In the state of Maryland, it's pretty tricky.
First, Cook Case had to apply to be the guardian of her own children.
And I was denied 3 times. They said, no, you're not fit to be the guardian for your children, which was a little strange, but it was more of just a paperwork thing of checking the wrong box.
Next, she had to buy bonds, find a company, pay for them out of pocket, go to the court, then apply for the money to be released.
And then once you get that done, you have like a limited amount of time to get to the bank and make sure the money is released into these very properly titled accounts, and if like one word is wrong on it, then the court will say this is wrong and you have to go back and forth.
It took a while.
She passed away last October, and it was the end of August that I finally got the account set up.
So tricky, maybe an understatement. The sad part? Cook Case's mother-in-law never meant for this to happen.
I have to imagine that when your mother-in-law did this, she didn't.
She had no idea.
She also didn't know that the process could have been a lot simpler.
If her mother-in-law had simply set up a trust for the children, and that money had funneled into a trust or existed in a trust when she had passed, everything that she has been through could have been avoided.
Nicole Hewitt's business is preparing people for the end. It's not pleasant to think about, but saves her clients' families time, money, even relationships.
If there is a situation where you get to a point where you can't speak your wishes or you're not competent to make those decisions, then it becomes a whole court process. And that really can lead to some dissent between family members.
Her advice is to have the tough conversations now and routinely sit down with an expert instead of an online form.
When they have bought a house, when they've had a child, when there has been a birth or a death in the family or some sort of financial change.
The alternative, as Cook Case learned, can mean months of wrangling when you just want to honor your loved one's wishes.
God forbid something happened to you and an aunt or uncle or grandparent is stepping in to care for them. If you've left, means to support them, it'll be very difficult for them to access that.
Pre-planning takes the guesswork out of deciding final arrangements. It can also be less costly. Many funeral homes will allow you to lock in today's price rates. And we asked Nicole a lot of questions on this topic, too many to include, like what you should do with your social media assets. And you can see those answers and more on our website, WMAR2news.com/consumer.